Solicitor General v. Metropolitan Manila Authority. Facts: in Metropolitan Traffic Command, West Traffic District vs. Han Arsenio M. Ganong. The court held that the confiscation of the license plates of motor vehicles for traffic violations was not among the sanctions that could be imposed by the Metro Manila Commission under PD 1605 and was permitted only under the conditions laid down by Law 43 in the case of stalled vehicles obstructing the public streets. It was there also observed that even the confiscation of drivers' licenses for traffic violations was not directly prescribed by the decree, nor was it allowed by the decree to be imposed by the Commission. However, petitioners alleged that traffic enforcers continued with the confiscation of drivers' licenses and removal of license plates. DIR General Cesar P. Nazareno of the PNP assured the court that his office had never authorized the removal of the license plates of illegally parked vehicles. Later, the Metropolitan Manila Authority issued Ordinance No. 11, authorizing itself to detach the license plate/tow and impound attended/unattended/abandoned motor vehicles illegally parked or obstructing the flow of traffic in Metro Manila. The court issued a resolution requiring the Metropolitan Manila Authority and the Solgen to submit separate comments in light of the contradiction between the ordinance and the SC ruling. The MMA defended the ordinance on the ground that it was adopted pursuant to the power conferred upon it by EO 32. The Solgen expressed the view that the ordinance was null and void because it represented an invalid exercise of a delegated legislative power. The flaw in the measure was that it violated existing law, specifically PD 1605, which does not permit, and so impliedly prohibits, the removal of license plates and the confiscation of drivers' licenses for traffic violations in Metropolitan Manila. He made no mention, however, of the alleged impropriety of examining the said ordinance in the absence of a formal challenge to its validity. Issue 1. Ordinance 11 is justified on the basis of the General Welfare Clause embodied in the LGC. Held no ratio, the court holds that there is a valid delegation of legislative power to promulgate such measures, it appearing that the requisites of such delegation are present. These requisites are: 1. The completeness of the statute making the delegation, and 2. The presence of a sufficient standard. The measures in question are enactments of local governments acting only as agents of the national legislature. Necessarily, the acts of these agents must reflect and conform to the will of their principal. To test the validity of such acts in the specific case now before us, we apply the particular requisites of a valid ordinance as laid down by the accepted principles governing municipal corporations. According to Elliott, a municipal ordinance, to be valid, 1. Must not contravene the Constitution or any statute, 2. Must not be unfair or oppressive, 3. Must not be partial or discriminatory, 4. Must not prohibit but may regulate trade, 5. Must not be unreasonable, and 6. Must be general and consistent with public policy. A careful study of the Ganong decision will show that the measures under consideration do not pass the first criterion because they do not conform to existing law. The pertinent law is PD 1605. PD 1605 does not allow either the removal of license plates or the confiscation of drivers' licenses for traffic violations committed in Metropolitan Manila. There is nothing in the following provisions of the decree authorizing the Metropolitan Manila Commission to impose such sanctions. In fact, the provisions prohibit the imposition of such sanctions in Metropolitan Manila. The Commission was allowed to impose fines and otherwise discipline traffic violators only in such amounts and under such penalties as are herein prescribed, that is, by the decree itself. Nowhere is the removal of license plates directly imposed by the decree or at least allowed by it to be imposed by the Commission. Notably, Section 5 thereof expressly provides that in case of traffic violations, the driver's license shall not be confiscated. These restrictions are applicable to the Metropolitan Manila Authority and all other local political subdivisions comprising Metropolitan Manila, including the municipality of Mandaluyong. The requirement that the municipal enactment must not violate existing law explains itself. Local political subdivisions are able to legislate only by virtue of a valid delegation of legislative power from the national legislature. They are mere agents vested with what is called the power of subordinate legislation. As delegates of the Congress, the local government unit cannot contravene but must obey at all times the will of their principal. In the case before us, the enactments in question, which are merely local in origin, cannot prevail against the decree, which has the force and effect of a statute. To sustain the ordinance would be to open the floodgates to other ordinances amending and so violating national laws in the guise of implementing them. Thus, ordinances could be passed imposing additional requirements for the issuance of marriage licenses, to prevent bigamy, the registration of vehicles, to minimize carnapping, the execution of contracts, to forestall fraud, the validation of parts, to deter imposture, the exercise of freedom of speech, to reduce disorder, and so on. The list is endless, but the means, even if the end be valid, would be ultra vires. The measures in question do not merely add to the requirement of PD 1605 but, worse, impose sanctions the decree does not allow and in fact actually prohibits. In so doing, the ordinances disregard and violate and in effect partially repeal the law. We here emphasize the ruling in the Ganong case that PD 1605 applies only to the Metropolitan Manila area. It is an exception to the general authority conferred by RA number 413 on the Commissioner of Land Transportation to punish violations of traffic rules elsewhere in the country with the sanction therein prescribed, including those here questioned. The court agrees that the challenged ordinances were enacted with the best of motives and shares the concern of the rest of the public for the effective reduction of traffic problems in Metropolitan Manila through the imposition and enforcement of more deterrent penalties upon traffic violators. At the same time, it must also reiterate the public misgivings over the abuses that may attend the enforcement of such sanction in eluding the illicit practices described in detail in the Ganong decision. At any rate, the fact is that there is no statutory authority for and indeed there is a statutory prohibition against the imposition of such penalties in the Metropolitan Manila area. Hence, regardless of their merits, they cannot be imposed by the challenged enactments by virtue only of the delegated legislative powers. It is for Congress to determine, in the exercise of its own discretion, whether or not to impose such sanctions, either directly through a statute or by simply delegating authority to this effect to the local governments in Metropolitan Manila. Without such action, PD 1605 remains effective and continues prohibit the confiscation of license plates of motor vehicles and of driver licenses as well for traffic violations in Metropolitan Manila.